Case People versus Thomas Styron. Here we go.
Imagine walking into a courtroom thinking it's just another hearing, but within minutes the defendant is threatening legal sovereignty, the judge is snapping back, and jail time hangs in the balance. Welcome to the explosive case of People versus Thomas Styron, a drama packed with defiance, contempt charges, and shocking twists that'll make you question who's really in control. From legal debates about self-representation to unexpected medical claims and allegations involving firearms, this hearing has it all. But here's the kicker. Thomas believes he's not even legally bound by his own name. Yes, you heard that right. Stay tuned, because what starts as a simple procedural hearing spirals into chaos, contempt, and potential felony upgrades. By the end, you'll be asking yourself, is Thomas fighting for justice or digging his own legal grave?
Assistant Public Defender Otella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Thomas Styron insists, again, that he wants to represent himself. On paper, that's his constitutional right. But here's where things get complicated. Representing yourself in a felony case is like walking into a sword fight without armor. The stakes: 5 years in prison, multiple felony charges, and possible firearms allegations. Notice Judge Simpson's tone here, calm but firm. He's been through this debate before. Judges typically issue a Faretta warning, making sure defendants fully understand the risks of going solo. And yet Thomas seems convinced he can navigate the legal maze without counsel. Here's where I want your opinion. Would you represent yourself in a case carrying this much prison time? Or is Thomas setting himself up for disaster by refusing a public defender? Drop your thoughts in the comments below. This one's going to get heated.
Well, I thought we got rid of that issue the last time.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt.
And just like that, the tension explodes. Someone laughs and Judge Simpson doesn't hesitate. One more laugh equals 30 days in jail for contempt. This is where courtroom etiquette collides with personal freedom. Under US law, judges have broad authority to enforce decorum. Contempt of court isn't just about disrespect. It's about maintaining the integrity of the proceedings. Thomas, however, doesn't seem fazed. This early clash sets the tone for the rest of the hearing. A constant power struggle between a defiant defendant and a judge determined to maintain control. Audience question: do you think Judge Simpson's warning was justified here, or do you believe he escalated the situation unnecessarily? Comment Team Judge or Team Thomas. I want to see where you stand on this legal showdown.
Look it up.
you may need an attorney.
Your fault. Court calls the case of the People versus Styron. Recall.
You're compelling me to identify as Thomas Styron, the legal entity on this case?
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
Here's where things get really wild. Thomas claims the court is mixing up his legal identity with his sovereign self, classic sovereign citizen rhetoric. This isn't just legal confusion, it's a direct challenge to the court's jurisdiction. Judge Simpson knows exactly what's happening here. By refusing to acknowledge his legal name, Thomas is trying to sidestep the charges entirely. But courts rarely entertain these arguments. They usually backfire hard. This raises a bigger question for you. Should defendants have the right to challenge the very foundation of legal jurisdiction, or is this just wasting taxpayer dollars and courtroom time? Either way, you can feel the courtroom's energy shift here. Everyone realizes this isn't going to be a straightforward hearing.
Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of all,
I'm the
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Session QV trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
Boom. That's Judge Simpson laying down the law. After Thomas questions whether this case involves trust fraud and throws out claims about Social Security and legal trusteeship, the judge warns him plainly, keep it up, and your sentence will get worse. From a legal perspective, this is significant. Judges rarely issue verbal warnings unless they're preparing to enforce harsher penalties. If Thomas keeps pushing, he risks compounding his problems, and with multiple felony counts already looming, that's dangerous territory. Here's a thought. Is Thomas genuinely confused about legal terminology? Or is this a deliberate tactic to derail the hearing? Comment below. I'm curious how you interpret his behavior. This moment marks a turning point in the case, from procedural disagreements to personal conflict between the defendant and the bench.
You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. You can go right there. We're having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm Philippines on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs.
Now we finally get clarity on why Thomas is here. Charge 1, fleeing a police officer, up to 5 years in prison. Charge 2, assaulting or resisting an officer, another 2 years. Charge 3, driving with a suspended license, a misdemeanor, but still 93 days max. That's a stacked case before we even consider the possible felony firearm, charges the prosecutor hints at later. Here's the kicker. Thomas wants to represent himself while facing this legal minefield. And unlike TV dramas, judges won't hold your hand. If you represent yourself, you're bound by the same rules of evidence and procedure as licensed attorneys. Do you think Thomas truly understands the risks, or is this the courtroom equivalent of playing poker with your life on the line?
The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I don't understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit at some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Hout's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, account of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this for him to have more time with the video.
Okay.
And just when you think it can't get any worse for Thomas, the prosecutor drops a bombshell. They're planning to add felony firearm charges and assault with a deadly weapon. That's an automatic 2-year mandatory minimum per count if convicted. This is where the stakes skyrocket. A case that started with resisting arrest now flirts with the kind of penalties that can reshape a person's entire life. Here's the real drama. While Thomas worries about procedural misunderstandings, the state is quietly building a much bigger case against him. It's like watching 2 different movies play out in the same courtroom, one in Thomas's head and one on the legal record. Question for you. Do you think the prosecutor is overcharging to push a plea deal, or are these added charges justified?
And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceeding so you can get through that. Is that okay? How far, and I guess that was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about, you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about.
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So
This is where the defense's biggest frustration comes out. Thomas claims he's only had 45 minutes to review hours of bodycam and Facebook videos, 16 files in total. He argues he can't prepare his defense without full access. Here's the legal angle. Under the Sixth Amendment, defendants have the right to review all discovery, evidence the prosecution intends to use. If he hasn't seen it, it raises serious fairness issues. But the prosecutor pushes back, saying today's hearing won't use bodycam evidence anyway. Viewers, I want your thoughts. Should the court pause everything until Thomas reviews every second of footage, or is this just another stalling tactic? Either way, this tension sets up one of the most crucial battles of the day, evidence access versus trial speed, and it could shape the entire case moving forward.
I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
Gotcha.
prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to
Yeah.
try to. Okay,
Flint's definitely provided direction in regards to how I can go about getting this.
all right. Okay, so we'll need to then adjourn that. Have you? Well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
Judge Simpson presses Thomas on the logistics. Who's helping you? When are you reviewing the videos? How much time do you actually need? This isn't just small talk. Judges must ensure defendants have a realistic plan to prepare their defense. Thomas explains that jail staffing shortages and limited access have slowed everything. He claims even arranging sessions with officers takes multiple requests and delays. Here's where the human drama hits. Thomas is balancing serious criminal charges, health issues, and limited legal resources, all while representing himself. Meanwhile, the court has its own priority, keeping cases moving without indefinite delays. Audience question: if you were the judge, would you grant more time for evidence review or force the hearing forward to avoid wasting court resources? This moment shows just how high the stakes are when freedom, fairness, and the system collide.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also,
But you don't know total. You don't know total time how much there is.
and
You
also
just know that one.
since May, I've been fighting an illness that just recently the jails addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday, I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that. And
Out of nowhere, Thomas reveals another bombshell. He's been urinating blood, fighting infections since May, and claims the jail's medical care hasn't addressed it properly. Now, here's the legal twist. If a defendant's health condition prevents them from preparing an adequate defense, courts must weigh options carefully. They can grant temporary release for treatment, delay hearings, or require jails to provide better medical care. But watch closely. The prosecutor immediately argues the jail is handling it fine, and that medical claims shouldn't derail proceedings. It's a classic clash. Personal well-being versus courtroom efficiency. Here's my question to you. Should Thomas's medical issues factor into granting him bond or adjournments? Or is this just another layer of strategic delay? This exchange reveals how real-life health struggles can directly influence the pace and fairness of high-stakes trials.
it's like very lethargic and
Okay, I got you.
energy in that.
What do we,
Progress that as well.
what do we look like on the sixth? Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me.
You got all of the discovery. Like you got the, as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th. (2024) at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here and telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond.
Here comes the prosecution's heavy swing. They argue Thomas is too dangerous to be released. Why? Because during the alleged incident, he threatened to cook the sergeant, a statement they interpret as violent intent. But Thomas fires back. He claims Cook referred to taking legal action against the sergeant, not harming anyone. The prosecutor isn't buying it, framing him as reckless, threatening, and armed. From a legal perspective, bond decisions weigh 2 factors. Flight risk: will the defendant show up to court? Danger to the community: could their release cause harm? With allegations of firearm threats and resisting arrest, the prosecution pushes for a $50,000 cash bond, keeping Thomas in custody while he fights for his freedom. Audience poll: do you believe the bond is fair given the charges, or is the prosecution stacking the deck against him?
This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to amend the information and have serious charges against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. Said meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he is fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible rolling domestic, which led me being pulled over, me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the name system or whatever it is they use in the police cruiser. Make sure they iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
Go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intention of running or trying to avoid it at all. And I think my actions would suit such.
In this matter, I'm not gonna at this point change your mind, Mr. Styron, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations, I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other, going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th.
Judge Simpson drops his decision, bond denied. Thomas stays in custody. Why? Because the judge considers two things: the seriousness of the charges, fleeing police, resisting arrest, alleged firearm threats. Thomas's courtroom behavior in earlier hearings, which he says raised doubts about whether Thomas could follow rules if released. From a legal standpoint, denying bond is rare unless a defendant poses a clear danger or risk of flight. But here, the prosecution's narrative of Thomas as volatile and armed clearly influenced the decision. Do you think this was the right call, or should Thomas have been given a chance to prepare his case outside jail, especially considering his health claims? This ruling sets the stage for everything that follows. Thomas must now fight his legal battles from behind bars.
And I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical were to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that. And I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and trying to represent myself.
Oh no.
And in regards to the medical thing, I reported this in May. It took until I got a flood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom or this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, four times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunity.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Styron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
Judge Simpson gives one last sharp warning: representing yourself is not a game. He reminds Thomas that even though it's his constitutional right, serious charges like these demand legal expertise. This moment is almost paternal. The judge isn't just maintaining control, he's trying to protect Thomas from himself. But Thomas stays defiant, convinced he can handle it. Here's the irony: by insisting on self-representation, Thomas takes full responsibility for legal missteps that could cost him decades of freedom. No attorney, no buffer, no safety net. Audience question: should judges force representation in cases involving potential prison time, or is self-representation a right worth defending, even when it's risky? This VO highlights the heart of the case, a battle between autonomy and strategy, where pride may cost more than guilt ever could.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Styron, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
Perfect. Because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send, to everybody.
They're $1? Seriously?
Tough down there.
I got about $500 in back. That. Okay.
So
Why? No, I'm just saying, if I can sell them for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Styron? I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges have ever had going front of whether Miss Fink that was able to have a conversation after the court time.
She's nicer. She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am. And so she has patience. Sometimes I don't.
Fair enough.
So you got to take it as it is. All right. Thank you. You do the same.
This hearing started as a procedural check, but spiraled into a storm of identity debates, medical claims, felony charges, and denied freedoms. Thomas Styron faces felony fleeing, up to 5 years, resisting arrest, 2 years, possible firearm charges, 2 years, minimum each. Judge Simpson's patience is tested. The prosecution builds a broader case, and Thomas, he's determined to fight his way, representing himself against the full weight of the system. What happens next could decide whether Thomas walks free, takes a plea, or faces years behind bars. If you found this case as shocking as we did, make sure to like this video, drop your thoughts in the comments, and subscribe for more explosive courtroom breakdowns every week. Trust me, you don't want to miss what comes next.